That ruling leading to concerns about digital privacy for women potentially seeking abortions. To help us, Danielle Citron. She's a professor of law at the University of Virginia School of Law with the focus of law and technology and the intersection of both. Thank you very much for joining us. Let me start with this. Should women be worried about having their information or data sold or seen on their apps, which I'm sure many think that it's private?
So in states where abortion is criminalized, then there's all sorts of circumstantial evidence that can be used against women who obtain an abortion or have even a miscarriage, then suspected of abortion, that can be used against them. And so that includes anything that we do with our phones, including our location tracking and, of course, our fertility tracking apps as well.
Is it illegal if you go from one state where abortion is illegal to travel to a state that is legal, and somewhere in the middle or on your way, have you done something wrong?
So what concerns me is that states will assert their jurisdiction over your activities that you have done in their states. It may be that we can't apply criminal law from one state to another, but it may be that civil penalties women can be pursued, and providers and others in out of states might be pursued for civil penalties. So I'm troubled by the out of state consequences for individuals when they go out of state and they exercise their rights in that state and it's legal in that state, that they might face repercussions in another state where they're from.
Can a lawyer or a police figure or the judge, can they get access to people's health records? I mean, it can't be that easy.
Unfortunately, it is. You know, you think of the federal HIPAA, which is an insurance portability law. It's not really a privacy law. It's got a sidecar of privacy, but it only applies to covered entities. And health apps, our Fitbits, our cell phones, our searches aren't covered by HIPAA. They're not a hospital, right? They're not a doctor. They're not a health insurance company. So it is perfectly legal for law enforcement right now to purchase access to data brokers that track your location and your use of apps, including information about potential pregnancies.
The HIPAA law already provides or affords individuals with some, I suppose, some privacy. Okay.
Yes.
Does Congress or do states need to enact additional legislation to provide additional protection?
They do. So I'm working with Senator Elizabeth Warren and Representative Sarah Jacobs on laws that would prevent the sale and sharing of your health and location data. So we know one can only hope.
If you go online now, you will see a number of articles, and half of them say to delete apps that are tracking, whether it's you're tracking your fertility situation or any other health issue because of this exact concern. Or should the general public be doing it, or is this an overreaction?
You know, I don't think it's an overreaction. The problem is it can only help minimize the collection of intimate data only so much. That is, you'd have to really throw your phone into the sea, right, to prevent the collection of intimate information that can be used against you. And so I hesitate to give folks advice like delete everything, because there will be other information that remains that law enforcement can purchase access to, including location. But I have been advising young people to stop using their fertility tracking apps.
What are you advising leadership in Silicon Valley? Because health apps have been, I mean, this aside, one of the hottest places where investment's going into. It's been, a lot of people are working on this, and people are benefiting from this as well.
Right. I mean, the reason why these companies are, you know, they're attracting venture capital investment is because the business model is based on the sale of intimate information. Now, I think that business model should be vanquished. We need a civil right to intimate privacy that prevents the sale and monetization of your most intimate information.
Don't people agree to the sale of their information, though, on the app when you download it?
Honestly, that's sort of an absurd suggestion. Do we read each and every privacy policy that we interact with? It would take weeks if we did that. And people just are, we're so harried, we're so beset by information, we just really don't understand the downstream risks of using these apps. We're not consenting to law enforcement, right? The idea that it's meaningful consent in the way that we think of HIPAA, when you're explicitly asked by your doctor, I'm going to use this information and only for the purposes of treating you, and they're looking you in the eyes. We just don't have that kind of meaningful, express affirmative consent when we deal with and interact with apps.
Right, right. Well, do me a favor, after you speak to Senator Warren, keep us posted on what the progress is. This is an important topic, not just for us, obviously, but also for the millions of women who are impacted by this. Danielle, thank you very much.
And Phil, can I
Sure.
say I have a new book coming out called The Fight for Privacy, Protecting Dignity, Identity, and Love in the Digital Age, and it comes out in October. So it'll be discussing all these issues.
Let's have you back before then, Danielle. Thank you.
Oh, thank you so much. I appreciate it.
All right.